Who's this now that's going, Mr. Fonzie?
Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
You know who he is? He was his Juliana sponsor.
Mr. Fossey, could you please state your name for the record?
Ben Fossey.
And are you employed by the Juniata County School District?
Yes, I am.
And what capacity?
I'm principal of Juniata High School.
And when did you become the principal of Juniata High School?
In January 2019.
And are you still in that position?
Yes.
Prior to January of this year, did you hold an administrative position within the district?
Yes, I did.
And what position was that, sir?
I was principal of East Juniata High School, Junior Senior High School.
Did you have petty cash at East Juniata High School when you were the principal there?
Yes.
Could you please turn to, I believe it's already open in front of you, policy 617 of the Juniata County School District, exhibit 18. See that in front of you?
Yes.
Were you familiar with that policy when you were the principal out of East Juniata High School?
Yes, familiar with that.
And did you follow that policy while you were principal at East Juniata High School?
Yes.
Were you aware while you were at East Juniata High School whether or not the procedures you were following at East Juniata were being followed at Juniata High School?
I was only aware of the procedures that we use at East Juniata, unaware of anything at Juniata High School.
So, in other words, when you came into Juniata High School, you had no idea what was being done or not done with regard to petty cash, is that correct?
That's correct.
And you were present and heard Mrs. Shipp testify.
Yes.
At East Juniata High School, who handled the actual cash at East Juniata?
The secretaries would handle the cash.
Who gave directions to the secretary as to what the petty cash was to be used for?
Ultimately, it would be me, but we had pretty firmly established protocol of what it could be used for.
Did you ever use the petty cash at East Juniata High School for staff lunches as you've heard described what was happening at Juniata High School?
No.
Was the petty cash fund ever used to purchase any birthday cakes or birthday presents for staff members at East Juniata High School?
No.
Were checks and cash handled any differently at East Juniata High School when they came in?
Checks and cash went to the district office.
So you didn't segregate the cash from the checks that came in?
That's correct.
And was there a specific place where cash was kept at East Juniata High School?
Yes.
And where was that?
That was in the back of the office.
And if you didn't use the petty cash for staff lunches and birthday cakes and presents, what did you use the petty cash at East Juniata High School for?
I believe the main reason was to purchase postage.
And was there even a discussion at some point that perhaps there was too much petty cash on hand at East Juniata?
I'm going to object, that's a leading question. Sustained.
Were there ever any discussions regarding the amount of cash on hand at East Juniata High School?
Yes.
And can you tell us the substance of those discussions?
There was rising cost of postage. Secretary requested that our next request be a higher amount of cash. And I want to review our postal purchases to make sure that was, we did that rightfully.
Did you feel that that was your responsibility as the building principal to look into that?
Yes.
Is that a job that you would have felt comfortable delegating to a secretary?
I'm going to object at this point. What was happening at the other high school is now relevant to what was happening at Juniata High School. I've allowed some of these questions to go on, but it has become increasingly irrelevant to the question before the board.
It's actually not irrelevant. If you recall during his cross-examination of Dr. Kovac, he implied that policy 617 was difficult to understand couldn't be followed by a reasonable individual. And that's why Mr. Fosse's here to confirm he was able to follow that policy at the other high school within the district.
Well, I will overrule the objection, but ask that you come to a stopping point on this line, things very fairly quickly.
I will stop right there. His witness.
Cross.
Following up on what your counsel for the administration just said, Mr. Foster, did you hear Mr. Kovac say that he thought policy 617 was unclear?
Yes,
Do you disagree with what the former interim superintendent opined in that regard?
I believe there was, I believe that the policy could be written better.
Okay. How could it be written better?
The responsible employee could be more specific, but I think in the context of leading the school, it would be the principal,
So you're referring, I believe, to the fact that responsible employee, as that term is used in the policy, is not defined, correct?
correct.
And in fact, wouldn't you agree with me that secretaries, to some degree, could fall within that category in as much as they're the ones that would be physically handling cash? I'm not suggesting exclusively, but that could be part of the definition, correct?
Correct.
Thank you. No other questions?
No other questions?
I have no clarification questions. The board have any questions? Thank you. You may step down. Next witness.
Rick Musselman?
I'm going to ask for an offer of proof as to this witness.
Please.
Sure. Mr. Musselman is the last superintendent before Mr. Yarger became full-time superintendent. He has knowledge as to policy 617. Mr. Musselman is also a resident of Juniata County and can testify with regard to societal norms and general community standards with regard to Mr. Apple's actions. And that goes directly to the immorality charge that's been brought against Mr. Apple as part of the statement of charges.
And when was Mr. Musselman the superintendent?
I believe the last was in 2014?
Okay.
2014.
Approximately how long do you anticipate direct examination?
If it's 5 minutes, I'm stuttering and stammering.
Okay. I'll allow the testimony.
Mr. Musselman, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
I do.
Thank you.
Mr. Musselman, could you please state your name for the record?
My name is this one? Rick Musselman. My name is. My name is Rick Musselman.
And are you a resident of Juniata County?
I am.
And how long have you resided in Juniata County?
For the past 27 years.
And were you a resident in Juniata County then during the summer of 2018?
Yes.
And what position do you currently hold?
I am the superintendent of Midwest School District.
And how long have you been there, sir?
I just completed 5 years.
And prior to holding that position in the Midwest School District, were you employed by the Juniata County School District?
Yes.
In what capacity, sir?
Superintendent.
And how long were you the superintendent of Juniata County School District?
3 years.
And prior to being the superintendent of Juniata County School District, were you an administrator anywhere else?
Yes.
And how long of a time period were you an administrator, sir?
I was an administrator since 1996. So.
Could you please look at it's Exhibit 18, Policy 617, is that right there in front of you?
Yes, sir.
And when you were the superintendent of Juniata County School District, were you aware of the existence of that policy?
Yes.
Did you sit through Mrs. Ship's testimony this evening with regard to how petty cash was handled at the Juniata High School?
Yes.
Are you aware of petty cash being handled like that at the Juniata High School while you were the superintendent?
No.
Is that something that you would have found acceptable as the superintendent of schools in Juniata County School District?
No.
And why is that?
First of all, it doesn't follow this policy as far as even having, it doesn't follow any standard accounting procedures that would be reasonable for any school district. And from my past experience as an administrator, petty cash was not used in that fashion. And we, in my district currently, we don't even allow petty cash in the buildings.
And are you aware that there's accusations that Mr. Apple removed property from school buildings to use for his own personal use?
Yes.
And would that be behavior that would have been acceptable while you were a superintendent in Juniata County School District?
No.
As a resident of Juniata County, do you find that sort of behavior acceptable?
Absolutely not.
Do you believe that that comports with community standards and community norms?
No, I do not.
What about the use of public dollars in order to pay for your own birthday lunch with other administrators?
No.
Is your opinion any different about it even if the employee is the number 2 person in the school district?
No.
And do you think it is acceptable to provide misinformation or lies about those actions? Is that something that is acceptable within Juniata County?
No.
No other questions?
Ross?
Is it Dr. Musselman, Mr. Musselman? Mr. Musselman. You were asked questions there by Mr. Knapp. By the way, do you know Mr. Knapp?
Yes.
How do you know him?
He is a solicitor from Midwest School District,
Where you are superintendent?
where I am superintendent.
So he provides legal advice to you on a regular
He does.
basis? You were asked a question by him concerning the word being used, accusations against Mr. Apple about removing items of furniture from school property. You said it was not acceptable, but you would agree, wouldn't you, that if it wasn't criminal, it's not scandalous? In other words, there are times when it's not improper to remove furniture from school property. You would agree, right?
If that was the case, yes.
Right, so your answer is completely dependent upon whether the removal was proper or improper.
I believe he said it was an accusation.
Right, so you're not making a judgment yourself as to what Mr. Apple did was
It
proper.
would be based on the
or improper.
intent.
It would be based on the intent. Correct. Do you agree with Dr. Kovac's testimony?
I was not here for Dr. Kovac's testimony.
Dr. Kovac testified that the policy number 617 involving petty cash was not clear and should be better. I assume you heard Mr. Fawcett say that, correct?
I did.
Okay. Do you agree with their assessment that there are deficiencies in the petty cash policy?
I believe this policy states that there needs to be receipts. It should be required. I believe that it spells out that it should be secure. I believe it spells out there should be an audit. It spells out all the essentials. A policy is not a step-by-step guideline. It is a policy set by the school district for the administrators to follow.
So you disagree then with Dr. Kovac's testimony that this policy is not a good policy?
Well, first of all, he wasn't here, and that's not what he said.
Well, that is not a clear policy. Do you agree with that or disagree with that?
No, I think it's a clear policy.
All right. The use of the word audit that you read here in this policy, who is supposed to be performing this audit?
Well, it doesn't state who is going to perform the audit. It says that there should be an audit. You have an administrator at each building. You also have a business manager, and you have a superintendent. Those are the procedures and the steps that should be set up. Policies are not necessarily procedures. They are policies.
So it sounded to me from what you said that it's really not clear who's supposed to do the audit. Would you agree under 617?
I'm going to object. I think he's mischaracterizing what the witness just testified to. He didn't say that it was unclear at all like that. We're going round and round. I think he's asked and answered.
The testimony was that policy is not necessarily as detailed as as written procedures or practices. So, well, why don't you rephrase the question?
Yeah, Mr. Musselman, does the superintendent have any responsibility in ensuring that an audit of this nature occurs?
It doesn't state that it's the superintendent's responsibility, it says that an audit should occur.
So does that include a superintendent or not as having responsibility to ensure the audit occurs?
Overall, the superintendent is responsible for what happens in the district. However, you do have designees, such as building principals, who are the lead administrator in the buildings.
Okay, what steps did you undertake while you were principal of Juniata when you were superintendent of Juniata County School District to ensure that an audit occurred of the handling of petty cash funds?
I did not conduct an audit of the petty cash at all. And quite honestly, there were different times and circumstances. This district was under strict or very serious financial troubles, and my focus was much significantly more invested than petty cash.
So you're testifying you didn't do anything?
I did not, no. I did not have time to do that in the 3 years I was here.
Did you verify whether anyone else conducted these
I
audits?
did not.
Okay, now you said that this policy should be followed, and yet as superintendent, you neither directly nor indirectly ensured that the audits that you say should be performed were actually performed when you were here, correct?
Correct, and I do use a local control form of management, where I do look at my principals as being the lead administrator in that district, or that building, and they are responsible also to follow the policies, as I did when I was a principal, when I audited my petty cash funds.
What did you do when you were principal of this school district, superintendent, to ensure that people were aware of policy number 617?
I didn't do anything specifically to make sure anybody was aware of policy 617. It is the responsibility of administrators to be aware of the policies. I believe this one was adopted in 2004 when Mr. Apple would have been a principal here in this school district. He possibly had even a role played in helping to write it. I haven't a clue.
Did you hear Mr. Kinzer's testimony?
Yes.
Did you hear Mr. Kinzer testify that even to this day, he's not sure he's read this policy word for word?
I did hear that.
Is that acceptable in your mind?
No, he should have read every single policy in there, totally recall it. No, that's understandable. You may not recall everything, but he should have read it.
Well, what steps did you take when you were superintendent of the school district to make sure that administrators read these policies?
I didn't take any specific steps. All the administrators had been here long before I was here. I didn't actually hire any administrators while I was here. So they should have been well aware of policies that were written in 2004 when I came in 2011.
So you're saying it wasn't your responsibility?
No, overall, it's my responsibility. I accept that. I do accept that. However, I understand that the responsibility of the building principal is to make sure that they're following policies as well.
I think you're arguing with the witness.
I have no other questions.
Any redirect?
Yes, actually, you were asked specifically about accusations. Could you please turn to tab 34? Mr. Musselman, that is a document that was signed by Ed Apple in February 11th of 2019. Could you read that first to yourself?
Is this really appropriate redirect? I mean,
Well, the fact that he downplayed the as being merely accusations and.
well, that's what he had testified. He had testified about accusations, and I think he was just clarifying that he was basing his testimony on accusations. He had no personal knowledge. He could read this and still not have personal knowledge.
Well, do you believe that confession that was signed by Mr. Apple is describing behavior that you find acceptable or normal within the Juniata County?
I'll allow that question.
All right, objection for the record, thank you.
I'm sorry, could you restate it just one more time?
I'll rely on this more.
Question by Attorney Knapp. Well, do you believe that confession that was signed by Mr. Apple described behavior that you find acceptable or normal within the Juniata County School District?
January 1? No.
And the use of tables as meat tables, personally. Is that acceptable behavior for an administrator in your opinion?
I don't really know what that means. I'd have to have, where are we using them as meat tables?
I really
I don't
think
know.
this is unnecessary testimony. I'd like to move on, please.
I have nothing else for Mr. Musselman then.
Board, have any clarifying questions? Thank you. Please step down. Next witness.
Next witness will be Scott Etter.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Mr. Etter, could you state your name for the record?
Scott Etter, my last name is spelled E-T-T-E-R.
And are you the solicitor for the district?
I am. I started working for the district in August of 1994, and I became the sole solicitor in or about 1999.
Now, prior to the matters that are giving rise to this hearing, had you ever met or interacted with Mr. Apple?
Yes, Mr. Apple and I met sometime around the time when he became Dean of Students, so we've known each other in a professional capacity for approximately 20 years.
Now, in the past 20 years or so, have you had occasion to work with Mr. Apple?
Yes, from time to time in his capacity, mostly as a principal, not so much as a Dean of Students, we were involved in matters such as student expulsion hearings, student discipline. From time to time, I got involved with him on employee matters, whether it be professional staff or support staff or otherwise.
And how would you characterize your working relationship with Mr. Apple prior to the matters giving rise to this hearing?
Very good. I have been representing school districts as a solicitor or special counsel for about 26 years at this point in time, and during that time frame, I've met many board members, many administrators, many teachers. Most of them have come and gone over the years. I would venture to guess that Mr. Apple and I probably have the longest lasting relationship of anyone in my entire career.
Now, as it pertains to matters giving rise to this hearing, when did you first become involved?
On January 22nd, in the middle of the afternoon, I received a telephone call from Mr. Miley, the business manager. He indicated to me that he had some concerns about some behaviors of the then superintendent. I don't recall him mentioning anything except for the wrongful or inappropriate use of a district credit card.
Was Mr. Apple mentioned during the course of that conversation?
No.
Did you take any action with regard to that conversation?
Because the matter involved what I viewed as a serious issue, if it was in fact true, and it involved the then superintendent, there were no administrators higher than him, I reached out to the board president, Mr. Snyder, and the board vice president, Mrs. Wagner.
And did the three of you meet?
We had a three-way conversation through ultimately, my recollection is Mrs. Wagner set up a three-way telephone conversation, and we scheduled a meeting for the next evening, which would have been the 23rd, and it was to be at Mrs. Wagner's office in the Newport School District.
And did you then have a discussion about what Mr. Miley had brought to your attention?
We did. The three of us met at Mrs. Wagner's office, and Mr. Miley was in attendance as well. He had some documents that supported the issues of concern to him. I already mentioned the inappropriate use of the credit card. He mentioned three other issues, and the fifth issue was something or other that Mr. Apple, or not Mr. Apple, or Dr. Yarger had done on January 1st at LAC. Didn't get into details about what that was, and my recollection is that Mr. Apple's name was not mentioned with respect to that issue, and he was not involved, as I later learned, with any of the other four issues that Mr. Miley brought to our attention.
So what what did you do then next after this meeting?
Mr. Snyder, as the board president, indicated that he would contact the other 7 board members, give them a general-only alert that there were some issues, potential issues, involving the then superintendent, and that I was being tasked to look into the matters.
And were you made aware at any point that an investigation was being commenced?
I was commencing it myself.
Was there any investigation outside of your investigation that was occurring that you were aware of?
As of January 23rd, no. About a month later, or perhaps a little bit less than a month later, I learned that the Pennsylvania State Police, and in conjunction with the district attorney, were engaging in a criminal investigation, but that was much later than January 23rd.
And did anybody contact you about your investigation in late January?
The meeting that I had with Mr. Snyder, Mrs. Wagner, and Mr. Miley ended somewhat late in the evening, and it's a decent drive from Newport to my home in State College. And I was leaving early the next morning. I was going to Arizona. My second son swims at Arizona State, and I was going there for the weekend to watch him in 2 different swim meets. On the 25th, I was back at my hotel in between sessions of the meet, and I got a phone call on my cell phone. It was a number that I did not recognize, but it came up. I believe it was Mifflintown, but it was Juniata County one way or another. It might not have been Mifflin County. I answered the phone, and it was Dr. Yarder.
And were you surprised to be hearing from Dr. Yarder?
Well, he was the superintendent. We regularly communicated on district business, but he was calling about the investigation that I was undertaking.
And did you discuss anything in relation to that investigation with Dr. Yarder?
I was somewhat surprised at first because it was just 2 days ago that I had had the conversation and the meeting with Mr. Snyder, Mrs. Wagner, and Mr. Miley, and I did not think that any one of the 3 of them would have told Dr. Yarder what I was up to. But we spoke for a moment, and he said that he was calling.
Hearsay. Respond.
Well, once again, I mean, it's a local agency hearing. The rules on hearsay don't apply strictly. If there's other corroborating evidence, then the hearsay is allowable under the circumstances. And I think certainly as Mr. Etter is allowed to continue testifying and relate to the exhibits and some of the investigation that was done, it'll corroborate the discussions.
Well, this is potentially extremely prejudicial. The administration had every opportunity to bring Dr. Yarder here and question him. They've chosen not to, and yet are trying to get in statements allegedly made by him. So my question to both the council is, why wasn't Dr. Yarder put under subpoena if his testimony was important?
Well, let me respond. I have not heard that the testimonies being proffered with regard to the truthfulness of Dr. Yarder's testimony, which would be your objection. I've heard testifying, Dr. Etter testifying about the chronology of his investigation, so.
And I'm trying to lay the foundation, which will be the other objection if I don't, as to how Dr. Etter.
I'll overrule the objection for all the reasons I stated, plus the response by counsel. Go ahead.
I spent the majority of the phone conversation, which was no more than 5 or 10 minutes, basically listening to what Dr. Yarder had to say. He mentioned only 2 of the 5 issues that I had been made aware of by Mr. Miley, neither of which had anything to do with Mr. Apple.
And then, upon your return to Pennsylvania, what, if anything, did you do?
On Monday, the 28th, we had an executive session of the board. I generally advised the board members what I was doing with respect to an investigation into issues involving the then superintendent. I did not provide them with any details of the issues that I was looking into.
Now, did anything significant happen during that executive session or afterwards with regard to Mr. Apple?
There was some concern that Dr. Yarger had somehow learned that I was involved with an investigation. When the meeting, the executive session broke up, one of the board members stayed behind and indicated that this board member had in fact called Mr. Apple after being informed of an investigation by Mr. Snyder.
And so what did you do with that information then, if anything?
I was simply aware of the fact that Mr. Apple, at some point in time prior to the 28th, was made aware of an investigation into certain matters involving alleged improprieties by the then superintendent, one of the issues potentially pertaining to Mr. Apple himself.
Did you then continue with your investigation?
Yes, on the following evening, the 29th, I had done some preparation prior to the meeting, but it involved mostly reviewing and becoming conversant with the documents and information that Mr. Miley had provided to us on the 23rd. I had reached out to the then superintendent, asked him to make himself available for a meeting that evening. The meeting was attended by Mr. Snyder, Mr. Wagner, and I obviously was there as well. I started the meeting by indicating to the then superintendent that some issues had been brought to my attention that were of concern to me. I was going to ask him about those issues and ask for his response. Two of the issues obviously were the issues that he had mentioned in his phone call to me on the 25th. Two additional issues had nothing to do with Mr. Apple, as did those first two issues. The fifth issue was what was he doing at Black Elementary School on January 1st.
And would you please clarify, this meeting you're talking about, that happened on the 29th?
Correct.
Thank you.
This was a meeting with the board president, Mr. Snyder, the board vice president, Mrs. Wagner, and me.
And the then superintendent?
Correct.
Thank you.
And when you said what was he doing at LAC on January, were you referring to the then superintendent or Mr. Apple?
The question was put to the then superintendent. It was a meeting involving him. Mr. Apple was not present in the room. Dr. Yarger appeared to be somewhat caught off guard and sort of stammered a response. And when it was clarified, what were you and Mr. Apple doing at LAC Tuscarora in the late afternoon on January 1st? At that point, he did mention the tables.
Here, second.
Well,
Same as before.
okay.
Well, for what purpose is this being offered, is my question.
It's laying the foundation as to the investigation that was being conducted, what was his basis for looking at Mr. Apple, and once again, there's going to be plenty of other evidence to corroborate and it's not offered for the truth of the matter of what Mr. Yarger necessarily is saying, but rather to advance and lay the foundation for the meat of this, which is what Mr. Apple did or did not do.
I understand your objection. Dr. Edwards explaining what he did in his investigation. I'll allow the question for that purpose.
And may I have a continuing objection on that basis?
Yes.
Thank you.
Thank you.
Dr. Yarger's general statement was to the effect that they were taking stainless steel tables, taking them to Mr. Apple's hunting land, and they were temporarily safeguarding them there for later transport to the high school.
Now, do you know where Mr. Apple's hunting lands are at?
In the course of my 25 or so years being involved as an attorney or the solicitor for Juniata County, I think at one time or another I've been to most every one of the elementary schools with the possible exception of Black. As I look at the map that I believe Mrs. Holderman identified and testified about during the initial evening,
It'd be Exhibit 21.
in my own mind, I find it easier to consider it in comparison to the Pennsylvania map. And if we look at a Pennsylvania map and with the turnpike running through the state, LAC essentially would be the equivalent of Pittsburgh Mr. Apple's hunting camp might not quite be all the way to Philadelphia, but it tends toward that direction. The high school might be Harrisburg, Mountain View, might be Hershey, and some of the other elementary schools in the area might be the equivalent of, say, Lancaster or York.
And so according to that, Mr. Apple would have traveled by York or Harrisburg?
It would be the equivalent of taking something from Pittsburgh with the ultimate intention of leaving it in Harrisburg, but with other options of Hershey, Lancaster, or York, but bypassing all of those, going all the way to Philadelphia, and then at some later date coming back to Harrisburg. It didn't make a lot of sense when I first heard it.
Well, what did you do next, if anything, after you were provided with this information?
I would say certainly at that point in time, 95% of my time in the investigation was occupied addressing and investigating issues involving Dr. Yarger. With the exception of the table, all of them had nothing whatsoever to do with Mr. Apple, or at least that was my understanding then, and it is my understanding now. But on February 1st, I met with Mrs. Holderman at her office at what was then renamed as Juniata Elementary School. And at that point, I was still unclear about everything that pertained to the tables at LAC on January 1st. And the majority of our meeting was addressing information pertaining to Dr. Yarger, not Mr. Apple. We did, however, and this is similar to what she testified to the other evening, talk about the fact that she apparently lives in the vicinity of Juniata Elementary School, and on the 1st, at some point in the day, she had driven by the school and noticed that the truck and the trailer, the district truck and trailer, were not in the positions that they were typically in, and that gave her some level of concern because she was aware of where the key was kept in a not necessarily secure location, and she was concerned that someone without authorization had moved them or had been using them. She arrived at school early the next morning. She asked an individual at the school if he knew anything about it, and he was the one, as Mr. Cook testified, put her in touch with Mr. Cook. Mr. Cook then mentioned what he had been a part of later in the afternoon on January 1st, and shortly thereafter, Mrs. Holderman, that same day when I met with her on the 1st, but shortly after, January 2nd, she reached out to Mr. Miley to ask him if he knew anything about the stainless steel tables from LAC. And according to Mrs. Holderman, Mr. Miley's response was he believed that they were at Mountain View. She went to investigate that issue, and they were not there.
Can I just ask for clarification, Dr. Netter? What you just testified to is in substance what Ms. Holderman told you during your meeting on February 1st?
Correct.
Thank you.
That was all, I did quite a bit on February 1st, but again, most of it involved Dr. Yarger. The next time I was involved on anything involving Mr. Apple was on February 4th. I met with quite a few people in the district at various locations on that day, but as it pertained to Mr. Apple, I started with Mr. Cook.
And if we could just hold on for 1 second there. Were you provided during your meeting with Mrs. Holderman with the inventory which has been marked with exhibit number 20?
Yes, the inventory that was dated, I believe, January 11th, and it was represented to me by Mrs. Holderman that was an inventory, the scrivener was Mr. Apple, and that was from driving around the district and recording what personal property was at which location on that particular day.
So then, on February 4th, you met with Mr. Cook.
In the chronology as it pertains to Mr. Apple, I started with Mr. Cook that day. He was brought into the room. I don't believe we had ever met before. I thought he appeared to be somewhat nervous coming into an unannounced meeting with the solicitor, having no idea what I wanted to talk to him about. And he related to me the same story that he told 2 hours ago on the stand, that he was there late in the afternoon, the two administrators were there, etc.
Did he say anything else that you thought was significant besides what he testified about the sweeper bags?
Well, I think he did touch on the issue that I thought was very significant, that he thought it was very peculiar that the top two guys, as he said on the stand and as he said to me, were there on a holiday, were there late in the afternoon, and were doing the heavy lifting of moving tables around. He had never seen that in his 20-some years as an employee in the district, and he thought that was peculiar, but again, as he testified to earlier, he is a custodian. It wasn't his position to question what the top two guys were up to, and he didn't.
And after you got done meeting with Mr. Cook, did you speak to anybody else?
I don't think it was in direct succession, but when I left Juniata Elementary School, I made my way eventually to East Juniata Elementary School, and I met with Nancy Craner. Nancy was someone, I didn't have the long-standing relationship with her that I had with Mr. Apple, but I had a relationship with her and had worked on various issues, including some special education issues, and I thought we had a pretty good working relationship.
Was that still on the fourth?
That was on the 4th, yes. We talked about a few issues involving Dr. Yarder. She had particular information about one of the issues that I was investigating, and when we turned our conversation to Mr. Apple, she indicated to me, as she testified the other day, that Mr. Apple had called her. Her recollection at that time was late in January, and he was upset and concerned, and among other things in that conversation, he said to her that he told Glenn Cook that he took the stainless steel tables, he stupidly told Glenn Cook that he took the stainless steel tables to his hunting land and that he was going to use them as meat tables. But she said to me, as she testified the other night, that Mr. Apple quickly added, "I was just joking. It wasn't true. That's not what I was going to use them for."
After your conversation with Mrs. Kramer, what did you do next?
Again, it was not in succession. I think, if I'm not mistaken, I stopped at East Juniata High School and met with Mrs. Varner, but eventually I made it to Tuscarora Junior High School, where Mr. Apple was for the day.
And did you meet with Mr. Apple?
I did.
How did that meeting go?
Yeah, this is on February fourth.
This was later in the day on February 4th. It was an odd meeting. As I said earlier, I think we were friendly going into that meeting. I think we were friendly going out of that meeting, but I was questioning him about potential issues that he had engaged in that were, if true, were inappropriate, and if true, could result in discipline for him. But he smiled, we shook hands.
What, do you recall any specifically what was discussed?
He said, "I was wondering when you were going to get over here."
And what was he referring to about that, do you know?
I'm assuming that he knew I was driving around the district and meeting with various people, asking them questions about Dr. Yarder's activities and his own activities. I started out asking him what he knew about certain things involving Dr. Yarder, and he indicated he didn't know anything about them. Excuse me. And I didn't have any reason to doubt that he was being truthful and forthcoming with me on those issues. I ultimately made my way to the tables at LAC and what he was doing on January 1st, and he repeated what Dr. Yarder had said to me on January 29th, that yes, they were there on the 1st, yes, they had taken a few tables, yes, they had taken them to his hunting lands, but no, they weren't there for meat tables. They were there for safekeeping purposes and were ultimately going to be taken to the high school. At that point in time, I didn't say to him, but I had that idea in my head of the Pennsylvania map, and it didn't make a lot of sense to me. I knew at that point in time that Mountain View itself was scheduled to be a repository for personal property that was not necessarily needed at the time, but was needed for the future. I was troubled by the fact that they had shown up late in the day, almost at the time that darkness would unfold. And I was troubled by what Mr. Cook had said to me.
Object at this point. I mean, the witness's subjective reaction, I think, is not probative of what the facts of the matter are. I would appreciate if the question would go to what actually happened as opposed to what the witness feels the case was. I mean, it's up to the board to decide what the gist of the matter is.
He was charged with investigating these accusations, specifically the ones regarding Mr. Apple. Mr. Apple, he's known Mr. Apple for many, many years. Mr. Apple's reactions, the way that he's acting, I think are certainly, fodder for questioning if he was acting differently or unusually. Mr. Etter could notice that after a 20-some-year relationship.
Yeah, I'm gonna overrule the objection. He's testifying about his investigation, so what he was thinking while he was performing the investigation would be part of that, so you may continue.
Well, I'd like to clarify something now. Am I correct that attorney-client privilege is being waived into this entire subject by the school district?
Well, I don't know that it's been asserted with regard to Dr. Etter's role as an investigator.
Yeah, it's not. I mean, he was taken out of the equation with the civil filing in Juniata County Court of Common Pleas. He's here as a witness.
Well, I'd like to ask, are Dr. Etter's notes from interviews going to be made available to us for review and for cross-examination?
So you've not asked for them at this point?
Well, I'm wondering what's going on here.
No,
Because this is an attorney.
hold on, answer my question, please. Have you made a request prior to tonight for those notes?
No, I have not.
I was not asked for that. I was asked for witness statements. I gave all the witness statements that I had. I turned them over, just as I said at the Loudermill hearing that I would do.
Okay, so let's proceed with the question.
I was saying that I had concerns as I was thinking of the geography of the county, or the school district, which is more or less the county. I was concerned that they had arrived late in the day, and I was concerned by what Mr. Cook had said, that he thought it was odd that the two head guys were there on that particular day at that particular time. We continued our conversation. It was not accusatory. It was not angry. We just kept talking. And after about 45 minutes, Mr. Apple said, "I'm not going to lie to you. We took them to my hunting land, and they were for my personal use as meat tables." I believe that that's what was the case from the beginning, but I thanked him for being honest and forthcoming with me at that point.
Prior to him saying that to you, did you threaten him with his job, or criminal charges being filed, or make any threats at all to Mr. Apple before he told you that?
I did not. We had, as I said before, under the circumstances, we weren't sitting at the Red Zone having a beer, enjoying ourselves. It was an uncomfortable situation. I was asking him about issues of potential wrongdoing on his part. It was a polite, it was a respectful conversation, and I did not threaten him with anything. In particular, I did not threaten him with criminal charges. I wouldn't have the power to do that anyway. And I did not threaten him with the idea of a statement of charges. That was not even in my thought process at the time.
Did he say anything else about any other items at that point?
Yes, he did mention to me that he had a meat slicer that he had placed in his truck, and that it was not for use at the hunting camp. It was for use by the boosters, and I'm not a hunter. I wasn't familiar with the term meat tables, but it made sense to me with what I understand to be a commercial-sized meat slicer, that it made sense to me that that wouldn't be used at the hunting land, but maybe I was mistaken with that. He also mentioned having a pot or pan or two, but then he started talking about chairs that he had taken and that he was quick to say with respect to the chairs that they were going to be used at the AEDY classroom or room, I believe at Tuscarora Junior High School. Given the fact that he had just confessed to me having stolen essentially personal property belonging to the district, and that in the next breath he was disclosing other matters, but indicating what I considered legitimate purposes he was going to put those toward. At that point in time, I took him at his word, and I believed that he was being truthful. We ended the conversation. I said that I would report back to the board, and I would be back in touch with him. I stood up, we shook hands, and I left.
Did you ask him to provide you with any additional information?
I did not. I did not think that there was anything in addition that he needed to provide me with. He did not indicate that there was anything else, and he did not say that I'll provide you with additional information tomorrow or at any other time.
Did he say anything to you about property from the other elementary schools on January the 12th, his removal of other items?
No, he did not. He did not mention that day, he did not mention any other elementary school, and he did not mention any other personal property when we met on the 4th.
Had anybody told you that other items were removed from another school, elementary school on January the 12th at that point?
No, the only people that I had spoken to who had direct knowledge of anything being taken from any elementary school, the only person who was singular was Glenn Cook. Christy Holderman and Nancy Kramer had provided secondhand information, but all of that pertained to what had occurred at LAC on January 1st.
So what did you do next then with this information?
The next morning, the 5th, I got a text from Mr. Apple, which wasn't shocking. He didn't text me daily, but I had received texts from him over time. And the text was cryptic in nature, and it had a couple images. I looked at it, and I saw some chairs and some other things on it, and I interpreted that to be what he had referred to the prior day as far as the chairs that he had gathered from somewhere in the district and was taking them to the AEDY, or at that point in time had taken them to the AEDY classroom. The text also referenced an email that I was going to get, and I think I responded and said I will look for it.
Did you get the email?
Shortly after that, I did get an email. This is also, I believe, the morning of the 5th. And the email had an attachment to it, and it had a list of, it had various categories and various items. And I looked at it, and at the time I interpreted it to be various things that Mr. Apple had done in his official capacity with the district, and properly so in his official capacity with the district. For example, taking the chairs and gathering the chairs and taking them to the AEDY classroom. There was nothing in the email or the attachment that specifically referenced January 12th being at any specific elementary school on his own on a weekend and removing personal property of the district, and I did not interpret the general language of that email to be in reference to anything on January 12th. And on February 5th, I had no background information to make me think that anything had occurred on January 12th.
Just to clarify, this email you talked about was from Mr. Apple, correct?
Yes,
Thank you,
there's an email and an attachment.
thank you.
Did you do any follow-up with Mr. Apple in response to this email?
Not specifically on that day. The next thing that I was involved with was that I met with Dr. Yarber on the 6th Again, there were a number of issues to address with him. I addressed them with him, and I addressed the tables from January 1st at LAC. He continued to maintain the safeguarding story, and at that point in time, I told him I didn't believe him. I told him that I had met with Mr. Apple. Mr. Apple had told me specifically that he, along with Dr. Yarger, had taken the stainless steel tables on January 1st, and they had taken them to Mr. Apple's hunting land for personal use as meat tables. And I asked Dr. Yarger, I guess in some sense as a rhetorical question, why would Mr. Apple tell me something that wasn't true when it would incriminate him, potentially criminally, but certainly with respect to his job with the district? And Dr. Yarger didn't really have an answer to that question.
What did you do with this information next then?
I met with the board in executive session on the 7th. I informed them that I had met with most of the people I felt I needed to meet with to talk about issues involving Dr. Yarger. Again, I did not tell them the specific issues at that point. I was still concerned about the possibility of having a board hearing as we're having tonight. But I did then say with respect to Mr. Apple that I had met with him on the 4th, and with respect to one issue, he had confessed to me that he had taken stainless steel tables along with Dr. Yarger from LAC on January 1st, that he had taken them to his hunting land, and that they were for use as meat tables.
What did you do then after this meeting with the board?
Well, that wasn't the end of the meeting. I had given them the update on Dr. Yarger. I told them where I was with respect to Mr. Apple, and I believed at that point in time that I was aware and fully appreciated things involving Mr. Apple, and I made a recommendation to the board for a sanction for Mr. Apple, which included the 5 days suspension without pay and some other things.
And what did you do after that then?
I did several things with respect to Dr. Yarger. The next time I did anything with respect to Mr. Apple was on February 11th in the morning. I texted him to see if he would be available to meet with me that day. The text is a relatively short text, but I did want to give him some level of assurance, and I did say in that text that, I'm paraphrasing, that your job is secure, but I need to meet with you about the sanction. And as of the morning of February 11th, that statement was true about his job being secure, and that statement remains true to this day. It was always qualified with the additional statement that if there is nothing else, your job is secure. And in the pleadings that were filed on behalf of Mr. Apple, paragraph 71 in the amended complaint, they recognize this.
Objection, this exceeds the scope of the question, it's not responsible.
Yeah, let's go to the next question.
Sure. Did you meet with Mr. Apple?
I met with Mr. Apple on the 11th. I brought with me what's been identified as
Exhibit 30
Exhibit 30
and 34.
and 34. Exhibit 30 was a document there. It's really one and the same document. They're numbered pages 1, 2, and 3. Page 1 and 2 is a summary of the discipline that Mr. Apple was accepting as a result of taking the tables from LAC on January 1st. Exhibit 34 is a statement with respect to what he had done on January 1st, ultimately ending up with the statement that he had left the tables at his hunting land for use as meat tables. I met with him. Again, it wasn't a pleasant conversation because of the circumstances. and because I considered him something of a professional friend. We had a respectful conversation. He did not challenge anything that I had written on those 3 pages. He signed it, I witnessed it. I asked him to make photocopies so he would have a record for himself. And this meeting, by the way, was at his office at Juniata High School, not in Tuscarora. He left his office momentarily. He went out and made a photocopy. He came back. We talked quietly for a couple more minutes. Again, I shook his hand and I left.
Did you, at that point, prior to him signing the document on February the 11th, did you make any threat against his job?
I did not.
Did you make any threat that criminal charges would be brought against him if he didn't sign that document?
I did not. I've been doing this, as I said earlier, for a little bit over 26 years, at that point 25 years. I have been in many disciplinary situations. I thought that what he had done was an incredibly bad exercise of judgment, but I did not think that the tables alone, particularly since at that time I was buying his narrative that he was under the influence of a bad actor, Dr. Yarger. I was not thinking of termination, and you would only have statement of charges if it were termination was an issue. I did not think that the tables at that point with the information I had on February 11th warranted termination, so I certainly didn't think of that, and I certainly didn't utter that as a threat.
So statement of charges was not mentioned on that day.
No.
Did you have any conversation with regard to how the sanction was to be imposed or carried out?
I believe he asked me, I had written, probably taking more liberty than I should have, that he would serve the 5-day suspension without pay on dates of his choosing, but in any event by June 30th, by the end of the fiscal year for the school district. I don't recall whether he specifically asked me for some clarification of that, or I offered it on his own, but I said, don't do something stupid like take the first day of hunting season and then post a picture of yourself on Facebook. I was trying to give him some level of guidance so he would not be further exposed to criticism. The hunting reference was solely mine. It had nothing to do with Mr. Snyder or Mrs. Wagner.
And what at that point, what were Mr. Snyder and Mrs. Wagner's role as of February 11th for this investigation as to Mr. Apple?
I had generally made both of them aware that I was making progress around the district, meeting with people. Again, 95 or more % of what I was doing involved Dr. Yarger, it didn't involve Mr. Apple. I had alerted them to my phone call from Mr. Miley on the 22nd. I had participated in a meeting with them on the 23rd. Those were both in January, and they were present for the meeting on the 29th. They had no direct role whatsoever in any investigation that occurred from that point through February 11th, other than the fact that because part of the investigation involved the superintendent of schools and there was no one above him, I was not going to be acting on my own as the solicitor. I was making them aware so that they had general knowledge of what was going on. But I directed the investigation. I chose the people to meet with. I met with them on my own.
And why then on page 1A of Exhibit 30, why was that specific language included in there?
Just so the audience understands, if I could just clarify that paragraph 1A provides for.
Kelly, do you mind using the microphone with the, thank you.
Paragraph A that's referenced provides for a 5-day unpaid suspension on dates to be chosen by the employee, but subject to approval of the board president and vice president.
subject to being completed before June 30, 2019. That was so the question was why were the board president and vice president mentioned in that? That's the question.
If we did not have the superintendent in a compromised position, it would have been the superintendent rather than the board president and vice president. And as things turned out, when Dr. Kovac was named interim superintendent on February 22nd, he then determined what days Mr. Apple would take. They were there merely as placeholders, and because I did not think it was appropriate for me to be deciding what Mr. Apple would be doing on any particular day. They did not, as it turns out, make any decisions or approve what days he would serve. That was done by Dr. Kovac.
And Dr. Kovac was brought in, according to him, February 22nd of this year, is that correct?
On February 22nd, the board took action at a regular board meeting to accept Dr. Yarder's resignation, and in separate action, they took action to appoint Dr. Kovac as interim superintendent.
And did Dr. Kovac then assume the helm, if you will, as far as deciding anything with regard to Mr. Apple's suspension?
Yes, I was not involved any further, at least for a period of time. And in fact, as of the 22nd, I thought I was done with this matter. Mr. Apple had signed what he signed on the 11th. Dr. Yarder had resigned, and it was accepted on the 22nd. I didn't think at that point that there was anything further to be done.
Now, did there come a point then that you became aware that the Pennsylvania State Police were doing an investigation?
I'm not 100% certain when I first became aware, but not later than February 22nd, I became aware because I received an email from the district attorney, and he was indicating in that email that he wished to get the cooperation of the district to include board members, employees, and me in an investigation that he was doing. I don't have a specific recollection, but at some point in time prior to the 22nd of February, I was aware because I think some board members told me that they had been contacted by Pennsylvania State Police Trooper Varner and asked to meet with him or answer questions that he had about allegations of wrongdoing by Dr. Yarder and Mr. Apple. And all board members and administrators or employees who told me of that, I had said to them at that point in time, I'm happy for you to talk with them, to cooperate with them, and we will do so, but I want to take care of the employment side with the district before we do any of that. So on the 22nd, I felt comfortable responding to DA Snook and said, we're happy to meet with you.
Well, why did you say don't cooperate or not, don't cooperate? Hold off on cooperation with the state police until after the district completes its employee matter?
I'm going to object at this point. I'm not sure how this is relevant to what we're here for.
Well, there's an accusation that's been made, and we've got board members that are subpoenaed, that they were doing all sorts of skullduggery, and in part in reliance on what Dr. Etter had told them to do or not do with speaking to the state police. So they've made it relevant, and I want to address it in Dr. Etter's direct testimony.
Well, let's try to cover it swiftly.
It's very simple. I told them, I don't want you talking to them at this point in time because I don't want you to be accused of the very things that they've been accused of right now. That they were pushing a criminal investigation as a means of addressing a personnel issue.
And did any of the four of you reach out to the state police and ask that the criminal investigation be commenced?
When you said, I'm sorry, the four of you,
The four of you, Mr. Snyder, Mrs. Wagner, I believe Mr. Miley and yourself were involved, is that correct?
I certainly did not ask that a criminal investigation be commenced. I'm not aware that any board member or any administrator in the district did, but I don't know what they do on their own time. But no one certainly made me aware that they had done so. And ultimately, Mr. Snyder, Mrs. Wagner, Mr. Miley, and I, at the DA's request, met with him and with Trooper Varner. It was the same meeting at his office in the courthouse on February 25th. And at that point, DA Snook informed the four of us.
Objection. This is hearsay again. Something the district attorney said, he's not even here.
it's not to the truth of the matter, it's what they did, which is what the allegations are. Mr. Apple is that these people were acting inappropriately and denying him his substantive and due process rights.
I'll have a question.
DA Snook indicated, and I believe Trooper Varner did as well, that they were undertaking an investigation of Dr. Yarger and Mr. Apple because of, I don't remember the term they used, but they had received a large number of contacts from citizens in the community who were asking or maybe even demanding that they institute a criminal investigation. It was purely by them based upon what he said, not by anything that anyone on the district side had done.
Did you do anything to cooperate with the criminal investigation? You personally?
The meeting that we had on the 25th was interesting, and I, in fact, had a little bit of a crossing of the swords with Trooper Varner. I wasn't seeing things entirely in the manner that he was, but I was asked either by him or by the district attorney to provide contact information for board members and employees and to reach out to them and ask that they cooperate with him in the criminal investigation. Because we were past resolution, or we had resolution with respect to Dr. Yarger and Mr. Apple, I indicated that I would do so. He gave me a list, I believe, by email on, I think, 2 separate occasions. I think I got help from Mr. Miley, but I'm not sure who. Maybe it was Mrs. Diggin, maybe it was both of them, to get the phone numbers and emails for some of the people that I didn't know or I didn't have their contact information. I gave those to Trooper Varner, and I also reached out to those people in individual emails, indicated that he was likely to be contacting them, and asked that they cooperate in whatever investigation he was undertaking.
And you turned over the exhibit 30 and 34?
That was much, much later. I would say that was within the last month. I think it was shortly before the arraignment. I was made aware that they did not have a copy of that document or those documents, and I believe it was Dr. Kovac who conveyed that to me, asked that I email that to them. I scanned them and emailed those 3 pages to them at their request. That was my only involvement. I did not sit for an interview or have a meeting with them or give a witness statement. My only involvement was the meeting on the 25th to act as a conduit as their request and to provide those 3 pages a month or so ago.
Now, at some point after February 11th of this year, was another investigation instituted by the district involving Mr. Apple?
As Dr. Kovac testified, and as I later learned, I was not initially part of that. I believe he met with Mr. Apple on March 6th, and that was where Mr. Apple used, in Dr. Kovac's words, the phrase slush fund. There was further information that was given to Dr. Kovac on March 7th in a meeting that he had with Mr. Kinzer. Again, I was not present for that, was not aware of it until later. But as a result of those, Dr. Kovac took certain action, and he then later reached out to me and asked me to get involved again.
And did you have any contact with Mr. Apple after that investigation was commenced?
I received a phone call from Mr. Apple. I'm nearly 100% certain it was March 12th, but I'm not absolutely certain. I believe it was a Tuesday because I was driving to a board meeting at Bellefonte, and those meetings are on Tuesday. Mr. Apple was concerned, again, that he was going to be terminated, and I repeated to him, as I had said before, if you have done nothing more than take the stainless steel tables on the first, you've already accepted and received your discipline. There's not going to be further discipline. But if you've done something more that I'm not aware of, that you've not told me about, I can't tell you what might happen to you. He then proceeded to tell me he was being asked to participate in an interview with the Pennsylvania State Police with Trooper Varner, and he asked for my opinion whether he should seek counsel. And I said, I'm not your attorney. I have a client in the school district who has an interest that is adverse to yours, but I said I thought you would be foolish to meet with the Pennsylvania State Police in a criminal investigation where you're a potential subject without having legal counsel. I don't do criminal work, and I don't know the criminal bar very well, but both Mr. Apple and I had experience with Nevin Zimmerman, I think a relatively young criminal defense attorney in town. I thought he had handled himself well in some student expulsion proceedings, and I suggested that Mr. Apple talk to Mr. Zimmerman.
And did you do anything more than in way of an investigation into these new allegations?
As I said, Dr. Kovac asked me to participate with him as he investigated some issues which turned out to be the use of petty cash for the birthday lunch and some alcohol consumption, and whether or not there had been a afternoon where he did not properly indicate that he was taking it off without pay. And as part of that, on March 21st, Dr. Kovac and I met with several people in the office at Juniata High School. Mrs. Shipp was not present that day, so we did not meet with her, but we did meet with Alyssa Adams, with Mr. Kisner, Mr. Fozzie, Mrs. Kyle, and Mr. Kondo. And we talked about what had happened at that lunch and essentially got the story that's the story at this point in time.
Did there come a time when you did speak to Sabrina Shipp?
It was the next day or a day later that I called for some clarification, and I felt foolish that I had made a mistake and I was getting Alyssa mixed up with Sabrina, and I immediately realized that when I was on the phone with her, and I got further information, and it was as she testified earlier this evening. She corroborated what the other individuals said, that she had gotten money and paid for the entire bill, and that she did not recall having been directed by Mr. Apple to mark that afternoon as a day off. And she further added that she believed she was a good employee, and when she was told to do something, she typically did it. So she would have been surprised if she had been told that and hadn't done it.
Now, was your investigation of this issue with the red zone put on pause at some point?
I was not having communications with Trooper Varner. I don't think he was particularly interested in talking to me any further after our dispute on February 25th. And I think he was communicating with Dr. Kovac at that time. Dr. Kovac advised me that Trooper Varner had asked that we put our investigation on hold while he completed his investigation. So for the next 3 to 4 weeks, we didn't do anything further.
Did your investigation recommence then at some point?
On April 18th, or before April 18th, I was contacted by Mr. Apple's then, and I believe still, criminal defense attorney Casey Shore, and we had various conversations about where we were in the process that ultimately ended up with a meeting with Dr. Kovac, Mr. Shore, Mr. Apple, and me at the district offices on April 18th.
And what was the purpose of the meeting on April 18th?
I did not think that there was anything else to talk about with respect to January 1st and LAC, and the only issue that I was pursuing, or at least going into the meeting that I was pursuing, is what had happened on January 19th of 2018 on Mr. Apple's birthday. The 4 of us were sitting in the lower level.
June 19th.
I'm sorry, did I say January? Excuse me, June 19th of 2018. The 4 of us were sitting at the table in the conference section of the administration building, and I started to go into some of the history with Mr. Apple of his own employment with the district, most of which I was generally familiar with since I said I had known him for that period of time, and also started talking about what apparently he had told Dr. Kovacs was a slush fund that whether it was a petty cash fund, or he said one of the former employees referred to it as the Mousy Mouse Fund. And he told me more or less what all the other witnesses had told me. He confirmed that he had 2 beers and a shot at the red zone, that the shot itself was provided without charge because the waitress was a former student of his, and that they had left there and they had gone. At that point, I was getting them mixed up. I think ultimately they went first to East Juniata Elementary School. This would be Mr. Apple, Mr. Kondo, and Mrs. Kyle, to look at the progress of construction. Then they went to Juniata Elementary School, which at the time, not sure if the name was changed, but it was from Anna Mifflin Town. And then they went to Mr. Kondo's house where he had another beer. So that appeared to me to be relatively straightforward. The only difference, what Mr. Apple was saying, that he claimed at the time that he had taken what he estimated was $30 from his own wallet and put on the table because I think his statement was that he was irritated that Mrs. Shipp had not left the tip, or no one else had left the tip. I followed up on that and talked to all the other people, and none of them had witnessed him leaving money on the table. No one said affirmatively that he did not, just that he hadn't done it while they were there. He then...
I'm sorry, that information Mr. Apple provided on April 18th?
On April 18th, he claimed that on his birthday he had put, he estimated $30 on the table. I talked to the other people and no one could confirm it. In fairness to Mr. Apple, Mr. Kondo said, I can't confirm that he did it, but it sounds like something Ed would do.
Now, was there any discussion as to any of the items removed from elementary schools during this meeting?
Well, he talked about what he had done at LAC on January 1st, and that wasn't a surprise to me. I had heard that all before. He had signed the confession. It wasn't anything new. But then he transitioned and he specifically started talking about January 12th, and that he had been at 2 elementary schools and taking certain things out from there. And I remember thinking, this is news to me, and I was surprised that he was talking about taking additional property of the district because, number one, he was sitting there with his criminal defense attorney and he wasn't stopping it. And number two, he was disclosing additional information that could result in an adverse employment consequence. I was asking the questions, I was taking cursory notes. Dr. Kovac was there as the real note taker. But you know, one of the takeaways from that meeting, particularly with respect to LAC, was that Mr. Apple had said, as I told you before, or some phrase of a similar nature, we took the tables to my hunting land for use as meat tables. So again, he was affirmatively stating what he had told me on February 4th and what he had signed on February 11th.
So how did the meeting end then?
I believe Dr. Kovac and I indicated to the 2 of them that we would discuss the matter and we would be back in touch with them when we decided what it was that we were going to do.
And was a determination made as to what you were going to do with this information?
Dr. Kovac, as interim superintendent, asked me to provide him with my opinion of whether the various activities on June 19 of 2018, January 1 of 2019, and January 12 of 2019 were sufficient in aggregate to support a statement of charges. And you know, I certainly, as a solicitor for many years, am familiar with potential wrongdoing by employees. But I did some research, and the case that I saw that I thought was particularly interesting and persuasive was the Commonwealth Court decision in 1980.
Objection. Now we're getting into court cases and other matters.
Well, I'm sure he's going to be asked what his basis of his determination was for the statement of charges, because he asked Dr. Kovac and Mr. Coleman that very question, and that pertains directly to the preparation of the statement of charges, which is where we're at in this narrative of what transpired.
Well, I'll tell you what, he testified that Well, he testified, he was asked his opinion on the statement of charges. I don't think he needs to get into the cases he relied on. If he's asked on cross-examination, no, he certainly should feel free to explain.
My answer was that I thought that there was a sufficient basis if he, as interim superintendent, wanted to proceed with a statement of charges.
Did you then, at that point, begin to draft a statement of charges?
Yes, I put together again at Dr. Kovac's direction a draft statement of charges.
And what happened with that draft that you prepared?
A second meeting, in-person meeting, with Mr. Shore and Mr. Apple was scheduled for May 10th. Between April 18th and May 10th, I had multiple conversations with Mr. Shore about the matter. And on May 10th, the four of us again met in the administrative conference room at the administration building. I orally went through the proposed statement of charges.
The fourth person was Dr. Kovac?
Yes.
Thank you.
Did either Mr. Apple or Mr. Shore dispute any of the oral statement of charges that you related to them?
Mr. Apple disputed one. Mr. Shore asked for a modification of another. The one that Mr. Apple disputed was there was a proposed charge that he unilaterally had instituted a parking permit fee, and he visibly reacted to that proposed charge and said that it was board approved. The wording of the issue involving alcohol in the proposed charges was that Mr. Apple was under the influence of alcohol when he was otherwise on the clock. I didn't use the words on the clock, but that concept. Mr. Shore, as I think a criminal defense attorney, asked me to consider modifying that language to say that he consumed alcohol on that day. I indicated at the table that I would check with the board secretary, Mrs. Diggin, on Mr. Apple's response to the unilateral institutional imposition of charges for the parking permit fees, and I indicated that I had no issue modifying the language as Mr. Shore requested. There was no dispute as to any other charge. In particular, the characterization of taking the tables from LAC on January 1st for use as meet tables. There was no objection to that whatsoever.
What about January 12th?
There was no objection to that whatsoever either.
Anything else with regard to the Red Zone luncheon on June 19th?
No other dispute as to anything else in the proposed charges that I orally recited for them.
And how did that meeting end then?
Again, a odd, peculiar meeting. It's not a pleasant meeting to sit down and talk to someone about issues that potentially could lead to where we are tonight. But it was a polite, it was a cordial, it was a professional meeting. Again, Mr. Apple stood up, and again, we shook hands as he left.
And did you indicate to Mr. Apple that a statement of charges was going to be prepared and presented to him?
I told him first that I would check with Mrs. Digon about his claim that they were board approved, and after that, at the direction of Dr. Kovac, it was a question that he could choose to resign, or Dr. Kovac was going to bring forward to the board at the next board meeting a statement of charges for consideration by the board. I left that meeting, which is downstairs at the administration building. I walked upstairs. I saw Mrs. Diggin at her desk. I asked her to check for me the minutes to see if, I asked her first, did she recall that, and I'm not sure what her response was. But I said in any event, please check the minutes and see if we can confirm it. Within a day or two, I did get an email from her confirming that, and I removed that proposed charge from the proposed statement of charges.
And did you ultimately discuss whether or not a statement of charges should be issued with the board?
On the board meeting on the 16th, which I believe is in compliance with the relatively new requirements of the law, there was a brief conversation in executive session with the board, wherein they were...
May 16th?
Excuse me, May 16th, yes. There was a brief conversation with the board during executive session to advise them of the specific statement of charges that they were going to be asked to adopt later that evening during public session.
Now, between the meeting with Mr. Apple and Attorney Shore on May 10th and that board meeting on May 16th, were you contacted by Mr. Apple or anybody else on his behalf related to the meeting of May 10th?
Yes, when the four of us, meaning Mr. Shore, Mr. Apple, Dr. Kovacs, and I, met on April 18th, Mr. Shore frequently indicated that he was a criminal defense attorney. He was not a school law attorney or an employment law attorney, and he was not really in a position to give Mr. Apple proper advice. He repeated that statement or a similar statement several times to me on the phone in conversations that we had in and around that time. On May 10th, he again repeated that, and I said that Mr. Apple would be well served to reach out to the Principals Association to consult with panel counsel that the association has and get advice from someone who was experienced in both school law and employment law. In response to your question, after May 10th, I was contacted by a gentleman named Tom Kelly, who is that panel counsel. He works out of an office in Media, Pennsylvania. I, like I think most solicitors in the Commonwealth, have had experience with Tom from time to time in situations like this. And we had several telephone conversations between the 10th and the 16th. He asked me by email to send him a written copy of the proposed statement of charges that he indicated that Mr. Shore and Mr. Apple told him that I had read at the May 10th meeting. I did do that. He also asked me to send him a copy of the Act 93 agreement. I also did that.
And did you ultimately draft a statement of charges that was adopted by the board?
Yes, the statement of charges that was adopted on May 16th was drafted by me.
And if you could just turn to exhibit number 1. Is that the statement? Is that the statement of charges that you prepared?
Yes.
On May 16th?
Yes.
Were you involved in the preparation of Exhibit 2, Statement of Charges of June 20th, 2019?
I was.
And how did it come to be that it's already amendment and supplement to May 16th, 2019 Statement of Charges and Notice of Hearing? Why was the amendment and supplement necessary to the May 16th Statement of Charges?
In the course of my career, I've probably prepared a statement of charges 30 or more times, and not once have we ever held the first night of the hearing when it is stated in the initial statement of charges. So the first change between the first one, Exhibit 1, and the second one, Exhibit 2, is to amend the date. At that point, Mr. Martin was on board as counsel, and we had jointly agreed that the initial date would not work, and we had at that point in time agreed to May 16th as the new date. There was a second issue which Mr. Martin had brought to my attention, and that was that in the document, the initial document, Exhibit 1, I wrongly had indicated that the vote required for dismissal was a simple majority of 5 votes. That's an embarrassing mistake on my part. I first prepared a statement of charges in 1995. I've amended my form many times over the years to comply with law and make it a better form. And earlier this year, one of my other clients, Belfont, was seeking to dismiss an employee. They retained Carl Beard to represent the administration. I was representing the board. I had a copy of the statement of charges that Carl was using. I liked it better than the form I was using, and I took it. I needed to amend it in many respects, certainly the statement of charges, the district, but it was a teacher, it was an administrator rather than a teacher this time. And for whatever reason, I read through that section, didn't catch the error, and it went through. Mr. Martin brought it to my attention, and by email prior to June 20th, I corrected it and said, yes, you are correct, that is an error. It does require 6 votes.
Now, did Mr. Martin provide you with any, what would be Exhibit 24, it's titled Partial Response to Statement of Charges?
Yes, that itself is not dated, but I believe it came with an email from Mr. Martin to me on March 31st, or on May 31st. Dr. Kovac and I carefully reviewed it. We made note of certain things that were admitted in this that were somewhat at odds with what we had said. For example, as I had said earlier, I think in the initial version we had them going to Juniata Elementary School first rather than East Juniata Elementary School. We corrected that. One of the other corrections, sometime I had heard they took 2 tables on January 1st. Other times I heard 3, so it was amended to say 2 or 3. Things of that change. Things of that order. I'm not sure that there were incredibly substantive changes, but there were corrections and modifications.
Now, in the partial response to the initial statement of charges, is there any response or affirmation made that Mr. Apple only signed a statement on February 11th after he had been threatened by you?
No.
Do you recall at any point Attorney Shore, either in person or over the phone, telling you that the only reason Mr. Apple signed the documents on February the 11th was because you had threatened him?
He never made such a statement in person or on the phone or in writing.
Did, in the brief time period that Mr. Kelly was involved, did he ever make such a claim?
I never met him in person over this matter. I met him in person previously on another matter, but he never, in this matter, made such claims.
In your conversation with Mr. Shore, was it ever claimed during those meetings and conversations that the tables were merely being stored by Mr. Apple at his honeymoon?
No.
And any of your telephone conversations with Mr. Kelly, did he ever make that statement that the tables were only being stored at Mr. Apple's, or merely being stored at Mr. Apple's honeymoon?
No, he did not.
When were you first made aware of the allegation that Mr. Apple only signed the documents on February 11th was because you threatened him?
I was in your office in Lewistown on June 20th. We were preparing to proceed with the hearing. I had called Mr. Martin to inquire about some matter, which I'm forgetting what it was at this point in time. He made me aware during that phone conversation that on June 18th, he had filed papers in the Court of Common Pleas in Juniata County. He neglected to extend the professional courtesy to provide me with copies of them at the time, but on the 20th, he did send them to me by email. I reviewed them. That was the first and only time that that issue was raised.
And if you could look at Exhibit 31, please. Is that a copy of the complaint that you just referenced?
Yes.
And is part of that same civil action is a petition for preliminary injunction also filed by Mr. Apple?
Yes.
And if you could turn to tab 32, please.
I'm there.
Is that the petition for preliminary injunction that was filed?
Yes.
And if you could turn to tab 33, please. Was this affidavit included as part of that filing in Juniata County?
Yes.
And do they contain similar allegations about your coercing Mr. Apple to sign the statement February 11th?
I object to that question. I think the documents speak for themselves.
Well, that's the allegation that's been made. I'm using his.
Overruled. Proceed.
Yes, for example, in the complaint, in paragraph 18, it states, quote, Eder putatively acting at the direction of the board of directors threatened Apple with the filing of charges if Apple would not agree to an unpaid 5-day suspension, period, close quote. Paragraph 19 provides, quote, Apple disputed the disciplinary action form which Eder had prepared specifically that Apple did not intend the furniture to be used as, quote, meat tables, period, close quote. Rather, Apple's intent was for the tables to be used in an athletic concession stand for the benefit of the district, and it was then Superintendent Garger's intention to use a table in his possession for a, quote, meat table, period, close quote. That same paragraph, or those same paragraphs in identical or substantially identical form appear in paragraphs 9 and 10 of the petition. And they appear in paragraphs 11 and 12 of the affidavit.
So at 30, 31, and 32,
31, 32, and 33.
I knew that. 31, 32, and 33, those allegations were consistent throughout.
Yes.
Were those allegations consistent with your recollection of what transpired between you and Mr. Apple, which you already testified to at some length?
No, they differ markedly from what he said on February 4th, what he said to me on February 11th, the document he signed on February 11th, what he said on February 18th.
And are those allegations what is referenced in Exhibit 3, paragraph 9, it's on the second page?
Yes.
Statement of charge of July 22nd.
The particular issue, as I understand it, is that the petition and complaint both include verifications to the court that the statements are true and correct to the best of his knowledge or information and belief, and the affidavit itself speaks for itself. So he either was lying in the statements of the complaint, the petition, and the
I'm going to object at
affidavit.
this point. I mean, this was gone over with Ms. Holderman. This was gone over.
Well, it's
They have already gone on record saying they are not seeking to impose discipline as a result of a breach of Section 4904 of Title 18. The district has already taken that position. Now the testimony this witness is giving is suggesting that they're trying to play the part of criminal prosecutor to establish that my client violated some criminal law that has never been charged in any court. And this is wholly inappropriate, and it's invalid as a charge.
Well, I didn't hear that as part of the question. On the other hand, is it really necessary to ask this witness?
Well, yeah, because of the fact that he's the individual that is being maligned in those complaints.
Well, you've asked him, is what was in the court filing inconsistent with what really happened? He said, yes, it's consistent.
And also, just to add on to what Mr. Martin said, when those questions were asked of Ms. Porterman, he skipped over charge 10, which is in the alternative, he lied to Dr. Eder, and that everything that he's saying in the complaint petition.
Dr. Eder didn't prepare this exhibit.
Correct.
All right, let's move on. Just think, but for different reasons.
Were you consulted, you did not prepare exhibits 3, correct?
Correct.
Were you consulted in the preparation of that with regard to paragraphs 9 and 10?
I was.
And do you believe what was averted, the complaint, the petition for preliminary injunction, and the affidavit was inconsistent with what Mr. Apple told you during your investigation?
That is improper opinion testimony. It's the province of this board to make determinations like that. Doesn't matter if he's a school solicitor or a man off the street, that's not a proper question to a witness like this in a proceeding of this nature.
It's absolutely proper under the
Well,
circumstances.
you've already asked them that. It's been asked and answered. Let's move on. 10:15.
Is it the dawn?
In the drafting of exhibits 1 and 2, the two statements of charges, did you consider policy 617, which is exhibit 18, when you were drafting that?
I did.
Similarly, when you were drafting the first statement of charges in the amendment, did you consider exhibit 19, policy 706.1, disposal of surplus property?
I did.
You can turn to exhibit 25. Are you familiar with that document that's been marked exhibit number 25?
I've seen it previously, yes.
And can you just for the record tell us what that is?
Again, I'm not a criminal defense attorney, nor have I worked in the DA's office, but as it indicates.
I have to object. What relevance does this possibly have?
Okay, relevance.
Well, it's to charges 11, 12, and 13, which he asked specific questions to Mrs. Holderman about, and she indicated that she was not involved with that. Dr. Vetter has advised that he consulted with the preparation of the statement of charges with regard to that, so.
You're talking about exhibit 3?
Exhibit 25,
No, but when, I understand. In what context are you asking about 25?
Attorney Kellum, I'm having trouble hearing.
I'm sorry. In what context do you want to ask about exhibit 25?
with relation to paragraphs 11, 12, 13, and 14. 11,
Of one exhibit.
It's the statement of charges marked as exhibit 3. And the document supports those allegations in 11, 12, and 13. The charges were filed on a particular date for particular offenses against Mr. Apple.
Is there any dispute that paragraphs 11, 12, and 13 are factually accurate?
Those are factually accurate. What I don't understand is what 25 has to do with that, because 25 looks like a docket from a case in 2011 for a charge that was dismissed. That's what I don't understand.
That's a fair point.
It also pertains to, with this docket, if you look on, it's page 3, it talks about witnesses being subpoenaed to testify in the case that's the subject matter of what we're here for.
I'm sorry, I'm looking at the third page of exhibit 25, and I see things pertaining to 2011. I don't see anything pertaining to the current matter.